Good afternoon and welcome to the Eastside Recovery Hub Financial Webinar Series hosted by One Redmond. My name is Christina Hudson and I am Executive Director and I will also be your moderator for today. All our Eastside cities and chambers are partnered together to give the highest level of support to our local business community. And I want to thank all our partners, our Eastside cities and our chambers for the work that they are doing. I want to please note, if you need to see an advisor for technical assistance, please reach out to your local chamber or cities, or you can go to the new restartup425.org website to sign up and someone will contact you. Today's webinar is part of our financial resource webinar series and is focused on managing cash flow. Our previous programming focused on opportunities for accessing capital, and this included the SBA's Economic Injury Disaster Loan and the Paycheck Protection Program, in addition to the Pandemic Unemployment Assistance Program that is available under the CARES Act. As you may know, applications for the disaster loans and payment protection programs have reopened this week. We want to encourage you to apply. Please note that our recorded webinars give an excellent overview of how to go through these applications and the process for those. Remember to utilize the SBA's online tool for identifying an eligible lender for these programs. And if you're having trouble finding a lender, you can review the online application opportunities that are now available via Intuit QuickBooks, Kabbage, PayPal, and Square. Recordings and resources are all available on the Eastside Recovery Hub webinar page, and that email or that website is eastsiderecoveryhub.com. So again, today we are here to talk about the strategies and tips for navigating rent relief conversations during COVID-19. Before we begin, I want to cover a few housekeeping notes. If you need technical help during the webinar, please use the chat box. We have staff on hand to try and help with any issues that you may be experiencing. We also have links to pertinent documents in that chat box that you'll be able to access. The tools that we have here will again also be available on our website. If you have questions for the speakers, please use the Q&A box. We will do our best to get to as many questions as possible. And this webinar is also being recorded, so we will send a link out to the webinar as soon as it is ready, along with any applicable resources. So we know that many business owners are seeking guidance, and we are hoping to help you navigate through all this information as we know it today. However, this is still a dynamic process, and as of right now, all the content you will hear on the webinar is accurate. So let's get going with our program. Today we have 3 speakers. We have Aaron Lang, Alex Andrea, and Tom Markle here with us today. Aaron Lang will kick off the program. He is a real estate attorney for Schwab, Williamson, and Wyatt. Next, we have Alex Andrea, office broker at Kidder Matthews. And to wrap our program, we'll hear from Tom Markle, CEO of Nelson Legacy Group, who will give us a perspective from the building's owner. And now I'd like to introduce Aaron Lang, real estate attorney for Schwab, Williamson, and Wyatt.
I know I'm not just talking to myself as usual. Can you hear me?
Yep, you're live now.
All right, excellent. This is fun. So coming to you live from my mobile command center in my kitchen, where I've been for, I guess, about 6 weeks now. My name is Aaron Lang. I am a real estate land use attorney with the firm Schwab, Williamson, Wyatt. We're a Northwest regional firm, full service firm, and kind of one of the 3 pillars of our firm since its inception has been land. And so we do all things that touch and concern real estate. We have a growing real estate and construction industry group within our firm. And I would tell everybody, a lot of the information that I'm going to give you is on our website. We have a COVID-19 sort of specific page there, and there are links to articles, both content that was prepared by myself and some of my colleagues, as well as just other resources. So in my allotted 15 minutes, I probably can't get into a great amount of detail, but I would encourage folks, if you're interested, go to our website. And Schwabe is SCHWABE. If you just put in Schwabe or my name, it'll come up and you can find those resources. I'm going to speak today about 4 concepts or 4 issues. One is called force majeure. The second is business interruption insurance. The third are leasing restructuring strategies. And the final one is the governor's proclamation of about just under 2 weeks ago on what we'll just call the eviction moratorium. Because other folks on the panel are probably as or more familiar with lease restructuring strategies, and because it's been going on now for a good month plus, I'm not going to spend a whole lot of time on that. But if at the end and there's time for Q&A, people have questions of me about lease restructuring, I'll be happy to give more information there. So I'm really going to focus my time on the force majeure, the business interruption insurance, and the eviction moratorium, and probably the bulk of my time on the last topic, because I think it's probably the most interesting from a legal perspective. And it's probably the one thing that a lot of the folks on the phone haven't already gotten some clarity on. So force majeure. Force majeure is basically a concept in our common law that talks about having some intervening event happen that prevents you from performing. And that's really key there, that concept of being prevented from performing. And immediately, of course, when the outbreak started to grow and the pandemic started to grow worldwide, and it looked like people might be losing their jobs or having business losses, there was an initial question of, well, does a global pandemic constitute force majeure? And I guess one of the themes that you'll hear from me today, and when you ask an attorney a question like that, is the answer to every question you ask an attorney is the same, and that answer is, it depends. And in this circumstance, when we're talking about force majeure and leases, commercial leases, it depends on the exact language of your lease. Typically, something is considered a force majeure event if it actually makes it impossible or practically impossible to perform under agreement. And so, for example, a typical force majeure event for a commercial lease might be something where you have like a total destruction of the premises due to, let's say, like a hurricane, or I guess we'll bring it more local to Washington, maybe like Mount St. Helens erupts again and covers an entire shopping center 10 feet in ash and burns it to the ground or something. So that might be looked at as a force majeure event because it's this exogenous external thing that happened that made it like literally impossible for the tenant to perform. When we actually start looking at the virus outbreak, as we all know, the thing that has actually shut down the vast number of businesses is not COVID-19 per se. It's not the virus itself that is shutting the businesses down. It's a government proclamation that is shutting the business down. And this is an important distinction to understand here in going back to what a force majeure event is and also what the terms of the lease say. If you have a standard force majeure clause, it's really going to be looking at something like if war broke out or if the premises were destroyed. And a lot of leases will actually even have separate provisions on the destruction of the premises or a condemnation of a portion or all of the premises. What happens when just something that is the proverbial act of God happens and you're unable to continue? In this case, if you look at a situation of a typical retail lease where the retailer itself was not deemed an essential business and was shut down by the governor, there could be an argument that constitutes force majeure if the definition of force majeure within the lease itself reference like a government activity or a government order. I will confess or say this, and I've asked a few brokers, including our next speaker, if anybody has seen a force majeure clause that was written in such a way so that it clearly anticipated a viral and pandemic, and unsurprisingly, there's no. And so I have yet to see from in my capacity as a practicing attorney, or in my other capacity, I've served on the International Council of Shopping Centers State Committee for the last 7 years, including 3 years as the state director and 3 years as the government relations chair. I can tell you, even with my involvement with ICSC and talking to those folks and those resources, I'm not aware of a lease that would clearly and expressly treat the pandemic as force majeure. However, once you get into the language, if you do have things that talk about an absolute frustration of purpose, the question is it permanent or is it temporary? And one of the other concepts with force majeure is usually force majeure is an event that allows for the parties to walk away from the lease completely because there's just no way that you can continue. And I point that out because the distinction here is it's not that the premises got buried and burned down by a volcanic eruption or a hurricane or something else. What we're talking about here is, at least we hope, a temporary interruption caused by the governor's order. And so it is my experience in looking at leases and looking at these languages and also looking at how they're construed under the law, that it may be difficult to wedge the coronavirus pandemic into a typical force majeure clause. The other thing that makes it somewhat difficult to put this into a force majeure clause is because there are things like the payroll protection program, SBA loans, the CARES Act, and there's relief out there. And what we're talking about here is excusing financial performance for tenants. Now, at this point, if all of the financial performance of tenants is excused or too excused, the landlords have a problem, and the banks have a problem, and everybody, and it rolls up from there. But in the simplest terms, from a landlord-tenant relationship, what we're talking about is essentially what we hope to be a relatively temporary frustration of purpose that may or may not excuse payment under the leases. And I'm going to typically say that the force majeure clause is not going to be allowed to essentially excuse 2 months of these 2 months or any months. I think, and I think that sort of dovetails a little bit into the lease restructuring, is if the force majeure clauses were drafted in such a way that this was going to essentially excuse performance, then I don't think we would see the degree of lease restructuring and amendments going on. I'm certainly not the smartest real estate attorney in the state. I'm barely the smartest real estate attorney in my kitchen right now, and I'm by myself. So I would suggest that the force majeure is probably not for the vast majority of tenants and vast majority of leases going to excuse performance. So then we look at sort of mitigation. And of course, the next thing that people have been talking about since March and looking into is business interruption insurance. And business interruption insurance is kind of an interesting thing because, again, whether or not your business insurance policy covers something, an interruption caused by a viral pandemic really gets into the details of what it actually says. I can tell you that the typical business interruption insurance is going to look at things that happen to the premises that cause or result in direct physical loss or damage to the premises. And I can tell you that the cleverest argument that I have seen to posture a coronavirus outbreak as a basis for business interruption insurance is the idea that the premises there's a physical loss or damage to the premises because there's been an exposure. The problem with that is that, premises, to date, very few exceptions. In fact, really only one that I know of with a nursing home. I've not heard premises that has been deemed uninhabitable by virtue of an exposure. And sort of worse yet, if you will, from a tenant's standpoint or a business standpoint, a lot of insurance policies actually have exclusions that deal with what would be done as either contamination or pollution. And so even if one were to tender a claim under the physical loss provision under business interruption insurance policy, it's more than likely that there may be an exclusion that the insurer would claim that the virus was either a contaminant or constituted pollution. So there would be a back and forth there. I'm going to be really curious probably in the next 9 months to a year to kind of see what shakes out in the case law, because again, we're sort of in uncharted territory, and the closest types we have to this situation right now is there are a series of cases that dealt with like mold infestations in businesses. And there were a series of cases that kind of went back and forth about whether or not there was a physical damage versus something that might be an excludable contamination or pollution situation. So the long and the short of it is, it's difficult. Now, there is one little ray of hope. Some business interruption insurance policies have provisions in them that provide coverage for civil or basically acts of civil or military authority. And that type of policy language, I think, would probably typically fit pretty squarely, or I should say they like the governor's proclamation of everybody stay home, stay safe, and then deeming of business non-essential, so it has to remain closed. There's probably a pretty good argument that you could claim a business interruption based on that if your policy has that language and if there is no applicable exclusion. I'm going to move on, just briefly talk about lease restructuring strategies. So probably, again, just to reiterate, it's probably unlikely that a lease's force majeure clause is going to provide any sort of basis of relief. And so what we have typically seen going all the way back to March as the pandemic grew and the orders became stricter in terms of what people were and weren't allowed to do, we saw a lot of lease restructuring activity, and that actually continues. And I don't think that it is slowing down. I think that actually there are going to be a lot more lease restructuring activity. It's going to increase between now and probably June. Typical strategies, I'll just kind of mention this, and I know others on the call will get into better detail on this, but the typical strategies have been anything from literally the landlord being willing to waive rent for a month or two, to more typically deferring that rent amount. And the sort of just high level pointers I might give just as an attorney working on these things. In fact, I literally just got off of a lease restructuring call right before getting on this call is, the first thing I would kind of have everybody keep in mind is we're all in this together, and it is not well taken by a landlord to have a tenant be viewing the COVID pandemic as an opportunity to essentially renegotiate the entire lease. And I'm sure there's a few folks on this call that don't want to hear something like that, or that may seem a little abrupt or terse. I represent both landlords and tenants, so I have no particular bias or stronger affinity toward one side or the other. But my observations have been pretty warm that the old saying that pigs fat and hogs get slaughtered applies in this circumstance. Every instance in which I've seen a tenant essentially decide to try to completely restructure the entire lease or claim some special advantage or leverage over the landlord, if the landlord doesn't accede to other things, that hasn't gone well. And the rent there's an enforceable agreement unless you've got a force majeure clause or something else, which we've already talked about. What I have seen is a lot of interesting and creative things in terms of extending leases, and I've seen things where there is a genuine understanding that we are in this together and that there's a need for both sides to kind of share the difficulty and then ultimately reap the reward when we all come back. And I'll let others speak to that. I'm going to speak to the final thing I'm going to speak to here is the eviction moratorium. And I'm guessing, just based on chatter that I heard before we got on this call, as well as just kind of things that I've been reading in the news, both locally and nationally, that there's a lot of folks, both on the commercial as well as residential, sort of wondering, like, is rent just canceled, or can rent just be canceled? And full disclosure, I've had a number of folks reach out, industry groups, as well as large landlords and others reach out and ask about maybe having me put together a legal opinion on the legality or enforceability of the proclamation. I'm not going to get into any great level of analysis here, but what I'd like to do is just spend about 2 or 3 minutes and talk about the order and just give some of the parameters here and explain kind of what this means for commercial tenants. So the order was issued 2 weeks ago, or not quite 2 weeks ago, and it was it essentially amended some earlier proclamations. And what it does in essence is it creates a time period from February 29th, 2020 through June 4th, 2020, in which landlords and property owners are not allowed to assess or threaten to assess late fees, interest, and these things related to non-payment of leases. They're not allowed to raise rents, and the provision in this that has the landlords particularly concerned is that on the 4th page in paragraph 5 of the order, it says, except as provided in this paragraph, landlords, property owners, and property managers are prohibited from treating any unpaid rent or other charges related to a dwelling or parcel of land occupied as a dwelling as an enforceable debt or obligation that is owing or collectible, where such non-payment was a result of the COVID-19 outbreak and occurred on or after February 29, 2020. That's probably worth going online and reading yourself, but in essence, what this is saying is if a tenant is able to show that they were not able to pay their rent as a result of the COVID outbreak between 29, at least as this currently stands, through June 4th, it can't be treated as an enforceable debt or obligation, with one exception. It does not apply if the landlord, property owner, or property manager demonstrates by a preponderance of evidence to a court that the tenant was offered and refused or failed to comply with a repayment plan that was reasonable based on that tenant's individual financial health and other circumstance. The way that that last provision is written would suggest that this is only applicable to residential tenants. However, the governor's order mixes and matches language throughout, and so there are a lot of commercial. There is a strong belief that this was intended to and apply to commercial landlords as well. And what this essentially, and this does kind of go back into the force majeure, business interruption, and lease restructuring analysis, that basically this is not a get out of jail free card for payment of rent. In fact, the order goes on to say, the governor, I strongly encourage every tenant to pay what they can as soon as they can, so there is that in there. This is not a relief of the obligation to pay rent, but it has not been publicized as such or explained and clarified as such. And so I will just quickly go through. There are three potential kind of on its face challenges, legal challenges that landlords are looking at and bringing for this. The first one would be a constitutional impairment of a contract. In essence, although both the contract clause in the U.S. Constitution and the contract state constitution have, which that would sound like that any impairment of a contract is prohibited by the Constitution, there is a well-recognized exception that has been recognized going back to, unsurprisingly, the last global pandemic in the early 1900s, that recognizes that a bona fide exercise of the police power can be used to at least provide some relief. The Constitution, both the state Supreme Court as well as the U.S. Supreme Court have recognized, though, that you can't just make the rent go away. You can defer it or abate it during the period of the emergency and just make it go away. And that's something that is kind of missing from this proclamation from the governor. And it's something that's probably been missing in the public discourse on this, is that whereas the police power could be used to slow things down or defer things, you can't just take the rent away. And so that rent is still due and owing. And the question is, what then becomes sort of a reasonable plan? Without getting too much into it, I'd suggest that what's happened with that provision in that paragraph where it talks about, the tenant basically show that they didn't pay rent as a result of the virus outbreak, but then the landlord has to show that they made an individual reasonable repayment plan. I don't know if that structure passes constitutional muster, because it suggests that the tenant might be able to never have to pay the rent. That's problematic. That's also problematic under our federal and state due process clauses, because it has flipped the burdens both within the common law and the statute in terms of what a landlord and tenant need to show in an unlawful detainer or eviction action. And the possibility that the time period at issue here would extend both prior to and after the actual emergency period in which people were unable to pay due to the pandemic is also problematic from a constitutional standpoint. The final thing is there's an interesting difference between the Washington State Constitution and the federal Constitution on an issue like this. And our state Constitution has an absolute prohibition against taking private property for private use. In this case, one could argue that by telling a tenant they don't have to pay rent ever, they've essentially taken that rent income from the landlord and given it to the tenant, and money is property under our federal and state constitutions. So there could be a per se prohibition against this just being used as a permanent, you never have to pay the rent back. I've gone over my time, so I'm going to stop. I thank you for tuning in.
All right, thank you so much, Erin. We appreciate it, and we will take some Q&As here soon after all our speakers. Next is Alex Andrea, office broker at Kidder Matthews. Alex?
Hi, everyone, and thanks to the One Redmond team for having me on. I'm a commercial real estate broker with Kidder Matthews. We're the largest independent brokerage firm on the West Coast, and I specialize in office leasing and sales in the Puget Sound region. I've got a slide deck that I put together to help illustrate some of these points as well. So, as you all know, this situation is fluid and changing every day. And I hope to shed some light on best strategies for tenant and landlord communication during this time. Some different approaches our team has used in lease restructuring, as well as important topics concerning the rent relief discussion from the perspective of the tenant, the landlord, and the lender. So I wanted to begin here by posing a question to the group for all of us to think about before we get started. As these are interesting times, we may all be experiencing the same thing and finding ourselves asking the same question. And that is, what day is it? Sometimes it's hard to tell. And I think we're all feeling the cabin fever right now. So with that, let's move to the next slide here. So in all seriousness, the focus for today's webinar will be to share with you COVID-19's impact on the commercial real estate sector and how this situation is testing the relationships between tenants, landlords, and their lenders. This quote from Theodore Roosevelt spoke to me, and I wanted to share with all of you. In any moment of decision, the best thing you can do is the right thing. The next best thing is the wrong thing, and the worst thing you can do is nothing. So the overarching message of this presentation is that during these times, the best way to prepare is to take action, keep open lines of communication, and focus on a common solution between all parties. By now, everyone recognizes the havoc and uncertainty of the coronavirus's impact on almost every aspect of the commercial real estate sector. For example, as of the first week of April, 630,000 US retail locations have closed, with the office and other sectors experiencing similar impacts. The duration of this crisis is uncertain, but in this evolving situation, every landlord, tenant, lender, and investor is processing and planning next steps with respect to their real estate relationship counterparties, while at the same time determining the applicability, if any, of insurance coverages, the applicability, timing, and requirements of government stimulus programs, such as the CARES Act, and countless other business continuity challenges. As May rents and debt payments come due or past due, many have already reached out to their counterparties or their lawyers to discuss short-term solutions. These conversations are extremely important to have. And then, so this will bring me to the next slide. So let's first start off with the tenant side of the conversation. I'll cover steps that should be taken by all tenants to put their best foot forward in starting the conversation with the landlord if you are seeking rent relief. Our team has created downloadable PDFs for this presentation that include our rent relief checklist, a boilerplate rent relief request letter, and a list of business resources available to Washington tenants. And these should be available on your screen to help you follow along. So the first point here is to set realistic expectations. Tenants should set and seek goals that are practical and reasonable in terms of economics and duration and workable for all parties. Second, tenants need to be transparent in discussions with the landlord and be willing to provide evidence of the hardship your business has endured during this time. The following is our team's strategy for advising tenants in their request for rent relief. First, connect with your landlord as soon as possible. You should maintain strong lines of communication with your landlord over the next few months. You should also obtain all lease documents, including amendments, Review all relevant lease language with your tenant advisor and/or attorney, and draft a rent relief request letter describing the amount of relief requested. When drafting this letter, it is prudent for tenants to quantify the reduction in revenue due to the pandemic. Also, articulate all other measures being taken to reduce controllable costs. Detail all other forms of relief your organization is seeking, such as stimulus packages from the federal or state governments. Tenants should also be prepared to provide current and previous year's financial statements and sales reports if applicable, along with any other documentation that will help support their claim. Lastly, tenants must ensure that any agreed upon relief and repayment terms are clearly defined in writing and added as an amendment to the lease. So this will bring me to the next slide. And this is the topic of lease restructuring, which Aaron briefly touched on. I'm going to put in a little more detail here. This is the real meat of my talking points. So this should give you a good perspective on what our team is seeing in the market and different strategies being utilized to find solutions that benefit both the tenant and the landlord. Because of the unique nature of the root cause of the current real estate shutdown, landlords and tenants will likely be more inclined to play nice, as this is truly a collective problem and challenge that we are all facing. In addition, the landlord-tenant dynamic is further complicated by virtue of government-mandated business shutdowns in various jurisdictions and the new federal COVID-19 stimulus package, or CARES Act, that I'm sure most of you are familiar with. Today, more than ever, the playing field has been set for landlords and tenants to engage in a meaningful, transparent, and genuine lease restructuring dialogue. While these lease restructuring scenarios often run the gamut with respect to the tenant's economic and other performance-related requirements, these frequently could involve one or more of the following restructure scenarios. So the most common that we're seeing here is the deferral scenario. So in this situation, rather than providing full rent abatement, the parties may agree to simply defer rent by providing the tenant with a full or partial rent deferral for some period of time, with the tenant being responsible for repaying any deferred amounts under one of the various alternative scenarios. For example, many of the tenants we have worked with on this have been able to secure a temporary delay in the payment of base rent for a period of time, while continuing to pay their portion of operating expenses and amortize the amount of deferred rent over the remainder of the payments due this year. Next point here is full or partial rent abatement. So here the parties may agree upon a temporary rent abatement, which may range anywhere from a full rent abatement of all payable rent under the lease to a partial abatement of base rent only. The latter is more frequently employed as it represents an equitable middle ground in light of the landlord's ongoing property level expenses and, in some cases, lender mandated reserves. Next is the blend and extend scenario. Here, a temporary rent abatement or deferral may be handled via a tenant's agreement to extend the lease term. For example, the landlord may agree to a full deferral of base rent for 3 months in exchange for the tenant agreeing to add an equivalent three-month period to the end of the term. Theoretically, this avoids the impairment of the value of the asset, as the landlord maintains the number of rent-paying months that existed pre-COVID-19, which directly impacts the value and income production realized from the lease, and which figure a lender, future buyer, or investor will utilize in calculating the property's appraised value and or purchase price on the basis of a market cap rate. This is an important piece for tenants to be aware of, because when tenants aren't paying rent, that rolls downhill and puts a strain on the asset. So last point here is going to be talking about the security deposit. So another creative solution we're seeing is tapping the security deposit to provide short-term relief. We've seen agreements reached where the landlord can apply some or all of the cash security deposit to rent shortfalls and provide a liquidity solution for both parties during the short term. This agreement could include replenishing of the security deposit at a later date or over time, or could treat the reduction as a burn down or burn off of the deposit. So that covers this slide. Now moving to the next. Let's shift gears here and talk about this situation from the perspective of the landlord and the lender. So let's talk about reviewing lender issues. Before considering whether to grant rent relief, landlords should carefully review loan documents where applicable. Questions pertaining to this issue would include, is the landlord permitted to grant relief without obtaining its lender's consent? Do the loan documents require a landlord to notify the lender of any requests for rent relief, or are they simply required to copy the lender on any formal correspondence with the tenant? Has the tenant stopped paying rent while the parties negotiate the terms of a potential deferral? Do the loan documents require the landlord to enforce the terms of the lease against the tenant? These are all questions that require landlord attention and should be carefully thought out as the situation progresses. Before taking any action, landlords should confirm that they are complying with obligations under their loans. Once a landlord has confirmed it is in compliance with its loan documents, it should still consider looping in the lender on any rent relief discussions. Transparency with the lender will often result in a more cooperative lender should additional relief be required down the road. Next, I'll be talking about the importance of confidentiality agreements when discussing these issues. Before beginning discussions with their tenants, landlords should consider entering into an agreement confirming that all discussions and negotiations relating to the proposed rent relief to be granted remain confidential and will not be disclosed to any third parties. And that all discussions and negotiations are non-binding and will not be deemed to waive any of the landlord's rights under its lease. So many tenants may ask for mutual confidentiality provisions here, especially if the tenant is required to submit financial information to the landlord. But from the landlord's perspective, it wants to ensure that tenants are not sharing the details of any proposed relief package with any other tenants in the building. Next point here, transitioning into some ways in which landlords can manage controllable costs. So there are some measures that landlords can be proactive with in order to lower their controllable costs. These include adjusting building operations to lower expenses, scaling back parking attendance, holding off on capital investments, trying to preserve cash flows, stagger work hours, and adjusting HVAC run times to reduce utility costs. So as you can see here, there are a short list of things landlords can do on the expense and capital control side. The key here is to know the ins and outs of your leases and communicate effectively with your tenants. So last point on this slide is going to be the perspective of the lender. So right now, lenders are focused on their regulatory obligations and needs to comply with laws. So one difficulty is to make sure that what they're allowing their borrowers to do is going to be okay from a regulatory standpoint. Landlords have reserves for FF&E and for capital projects. The question here is, will lenders allow landlords to use these reserves for debt service during this time? So these are all issues that will need to be confronted on the regulatory side for lenders in order to roll out these relief solutions. So finally, I know this is a lot of information to take in, and I appreciate everyone listening. So in closing, our opinion here at Kidder Matthews is that it's in the best interest of all these stakeholders to try and work through these situations. I think we'll all adapt and come out stronger than we were before. And to end on a positive note, I encourage everyone to look up and look forward. The real estate industry has made it through a lot, from interest rates hitting 18% in the 80s to the dot-com bust and 9/11 attacks, to the credit crunch in 2008, and now into this. We will get through this, so look up and look forward and find solutions. Finally, I also encourage everyone listening to stay on top of this situation by attending forums such as this and others. It seems like I'm receiving, close to 10 invitations per day to different resources from various organizations. And I attend as many as I can in order to better serve my clients and myself. And finally, I would encourage all of you to communicate, reach out to our team if you have additional questions, and know that we're all in this together. Thank you.
Thank you, Alex. Next, I'd like to bring in Tom Markle, CEO of Nelson Legacy Group. Tom?
In listening to Alex, I think you're going to hear a little foreshadowing of a couple of things I have to say. And I listened with a lot of interest to Aaron because I have had the force majeure conversation with tenants. I've had the business interruption conversation. And in terms of lease restructuring lawyers, well, I think with all due deference to Aaron, when lawyers get involved, I have the feeling it gets complicated and both sides lose. When you approach, well, I'll back up a little bit. Our business, Nelson Legacy Group, we have property in Redmond, Kirkland, and Eastern Washington. And most of our property is in Redmond and Kirkland, very, very heavy to Redmond. We have office property, but most of our properties are retail properties. And while we have some big tenants like QFC and Met Markets and Trader Joe's, Bank of America and Starbucks, a lot of our tenants are small businesses, small restaurants, sole proprietors. And so I think I have a feel for at least what a lot of the smallest are going through right now. If you approach your landlord to talk about rent relief, I think what you need to realize is it's a negotiation. And a successful negotiation is one in which both sides win. Both sides get something they want and they need and they desire. And so in going into that conversation, I think Alex had some good advice for you, but you ought to be thinking about what's important to the landlord. What is the landlord thinking about? Now, the first thing you ought to realize is the landlord doesn't want your business to fail. Landlord wants his tenants, their businesses to survive. And it's not just because we landlords are wonderful human beings, but it's a very practical thing. If a tenant's business fails, the landlord is going to lose, first of all, any hope of collecting the rent that the tenant was unable to pay today. But in addition, the landlord is going to face a lot of costs. Initially, there's the lost rent when the space is vacant and up for lease. There are commissions to brokers when the space is leased. Generally on a new lease, a tenant is going to want a financial allowance, a tenant allowance of some sort to get the space ready for their use. And that's a cash expense for the landlord. The new tenant may want a little bit of free rent as an inducement, and the landlord may be facing some legal fees to get the new lease in place. And quite frankly, in the current environment, there's also the realization that with business failures and the financial impact on the economy that this COVID-19 closures are having, that space might might sit empty for a while. So, you know, the landlord really wants to keep you going. The landlord has an incentive to work with you to help you survive as a tenant in a business. The second thing that you really need to think about is, you know, we're sort of, I wouldn't even say we're medium sized. We're sort of a big, small business. You know, we're not as big as the national firms. And there are a lot of landlords who only own 1 or 2 or 3 properties and live on the income those properties generate. So in a lot of cases, you know, your landlord's a small business too. I have a colleague who likes to joke that nobody likes the landlord, and the landlord always gets thought of as last. And you know, there's an element of self-pity and all that, I guess. But as a small business, I'm facing a lot of the challenges and problems that other small businesses are facing too. I have employees who have to get paid. I have property taxes I've got to pay. You know, it's nice that King County has delayed them for a month, but they didn't cancel them. I have insurance bills to pay, property insurance, liability insurance, on some properties, earthquake or flood insurance. On some of our properties have mortgages, so I've got banks that are eager to see me pay them every month. We have utility bills to pay. You know, the city of Redmond hasn't said, don't pay your water bill, don't pay your sewer bill, don't pay your stormwater bill. PSE wants to get paid. And properties, you know, require some ongoing maintenance. Some of the properties require some landscaping, there's trash collection. So, you know, not to cry on your shoulder, but I've got problems too, and I've got bills to pay too. And as a consequence, you know, cash flow is important to me. Income is important to me too. And the third thing, and both Aaron and Alex have mentioned it, is all of us landlords are really aware of the government programs that are out there. We're aware of the PPP program. You know, we know the money got used up on the first round, and that now there's a second round of money available. We know the banks are struggling to deal with all the applications, and I guess that's to be expected. This is something they weren't prepared for either. You know, we're also aware of the expansion of the unemployment compensation program, not only for gig workers and contract workers, but, you know, it's available to sole proprietors. And, you know, a lot of my tenants are sole proprietors. And not only is there a state benefit available, but there's the $600 federal benefit that folks, once they can get through the state website, are going to receive on a weekly basis. So, you know, those are all things that I, as a landlord, think about. So the bottom line is, okay, what am I doing with all this information? What am I doing with my tenants? We have in our business, about 110 tenants. And right now, 40 of them have received rent concessions from us. I expect more of them to ask for them and get them in the month of May. And ask is an important word. The worst thing for me as a landlord is for a tenant to go silent. I want to know what's going on with you. I want to know what your situation is. Please talk to me. Now, when we start that conversation, the first thing I ask the tenants is, are you taking advantage of the federal programs, the PPP program under the CARE Act? If you're eligible, are you filing for unemployment compensation? I want to make sure that you're helping yourself. I don't want to be the first person you go to for help. Quite frankly, I want to pay my bills, so I want you to be the last. I want to be the last person that you come to. And then secondly, when we talk rent, I think a lot of you are aware of it. There are really two elements for rent. Most of our leases are what are called triple net leases. There's a base rent component, and then there's a second component, which are the triple nets, the operating cost, the tenant share of the insurance, of property taxes, of maintaining common areas if there are common areas. And those are really, very direct ongoing cash costs that I have to deal with every month. For some tenants who have gross leases, well, all that's lumped into one monthly amount. But what I'm asking my tenants to do, and I have, as I mentioned, have about 40 who I've reached these agreements with, I'm asking them to pay those triple net and operating costs. Because we need that money to operate as a small business ourselves. But I'm generally agreeing to defer the base rent. Sometimes I defer both. It really depends on the financial situation of the tenant, and like Alex said, have your information together and be prepared to share that with your landlord. And we initially deferred for the month of April. We're now starting to defer for the month of May because it's clear that this thing, is continuing on. And what we're telling our tenants is when you can resume your normal business operation, we'll sit down and talk to you. And we're going to try and work with each of our tenants on a case-by-case basis. Ideally, they'll pay us back for the deferred rent over a multiple month period. But, it's very likely that some of our tenants are going to need to have their rent forgiven. So final advice to you. When you approach your landlord as a partner, not as an adversary. The two of you share a common interest in keeping your business to survive. And look for a solution that will create a benefit, gives the landlord something he needs, but also gives you what you need to survive as a business. So thank you.
All right, thank you, Tom. We're down to our last few minutes, and I want to go ahead and ask a question. And I believe this is probably an Aaron, but could be an Alex question as well. From Kaylin Adams, I have a 2-month deferment paying CAM only with a 36-month payback, but they want me to sign an addendum that says I waive my rights to any future deferment due to COVID-19. I don't feel comfortable signing this because I do not know how long this will go on. I'm also concerned that if this goes on longer than 2 months, I won't be able to pay back the deferment rent over the remainder of my lease because it would make my rent too high. I've asked to add that deferment to the end of my lease, but they have not agreed to that. Do you have any advice on what to do?
So this is Aaron, and I had to chuckle, and it's a good thing I was muted when Tom mentioned that, when the attorneys get involved, things get complicated. Truer words, my friend, but remember, we get paid by the syllable. I would be ethically prohibited from giving any sort of advice. But what I could say, and I'd echo one of Tom's comments here, is these are all negotiations. And I think that the one thing that I said, that Alex said and Tom said, and I think we should just keep repeating this, is we're all in this together. And I have yet to see a situation with a tenant that there wasn't some negotiation, and I have yet to see a situation that there wasn't some mutually agreeable, reasonable resolution. And that's the most that I could say without probably crossing an ethical line. But
Okay.
negotiation.
Well,
Tom,
thank you.
I think Tom or Alex could probably speak to it without getting in trouble.
Well, I think we're down to the last minute. I want to remind everybody that we are going to go ahead and follow up with an email with a link to the recording and these resources. If you have additional questions, feel free to reach out to us or to the Restart Up 425 advisors. I would like to thank our speakers again. I would like to thank all of you for participating. And again, our website is eastsiderecoveryhub.com. And thank you all again, and please stay safe and healthy.